Good day and welcome to yet another edition of Law Made Simple. We have been off for the last 2 or 3 weeks, and now that the festivities are over, we are back on again the first program for September 2019. In our last program, we looked at the Noise Control Act. And noise control is a very topical issue. In fact, always topical. And we started part one just before Carnival because during the Carnival period, it becomes even more topical. However, we look at part two today, our first program for September, because, as I said, whatever the month, whatever the day, excessive noise affects somebody in our community, and it is one of the popular areas of complaint by citizens. So just to briefly indicate, the problem is not noise, because we have noise every day. We have noise coming from different sources. And the issue really is excessive noise. The excessive noise. And just to highlight one or two areas we mentioned in the last program to put things into context. Section 3 of the Noise Control Act says, excessive noise, always unreasonable and always actionable. So wherever you have excessive noise, not just noise, but excessive noise, that is always unreasonable and always actionable. So the law seeks to protect persons in society from the discomfort, to put it mildly, of excessive noise. And Section 3 of the Noise Control Act says, just to rehash and refresh your memory, that every person in Grenada shall observe the basic principle that the making or continuance of excessive noise shall be deemed to be unreasonable and shall be actionable under this Act or otherwise, and the granting of permission to any person under this Act to operate a loudspeaker or a musical instrument shall not be deemed to constitute an authorization to such person to create or maintain a significantly higher volume of sound than is reasonably necessary to satisfy the primary purpose for which such loudspeaker or musical instrument is being operated. What amounts to excessive noise will be measured by the standard of reasonableness. That's Section 3. Let's just pause for one moment to internalize this issue of excessive noise, to be judged on the standard of what is reasonable. So even in situations where people are given permission by the authorities, by the police, to use a loudspeaker or to operate a musical instrument, if you use that instrument to a higher volume than is reasonably necessary for the purpose for which it was intended, then you cannot hide behind the fact that you have a license. You have a license to operate equipment. You have a license to, whether it's musical equipment or loudspeaker. The license is not to make excessive noise. So it is important to understand that even though permission is given, then within the confines of that permission, one should be reasonable in the use of the instrument so that it does not unreasonably affect persons in the community or in the immediate area. And the test of reasonableness, as we indicated on the last occasion, but just to rehash based on the area of focus today, is that a court in deciding the question of reasonableness under this act shall use the objective test of ordinary standards and ordinary sensitivities, and shall attach to purely personal sensitivities and idiosyncrasies only such weight as the court might deem necessary to prevent injustice. So again, what is reasonable for A, B, and C might seem unreasonable for X, Y, and Z. There are some people who may be described as having extra sensitivity or abnormal sensitivities, not in keeping with the reasonable standard of the man in the street. And therefore, the court in judging noise would not judge it based on persons who have particular sensitivities, but on the basis of the ordinary standards and ordinary sensitivities. And 4.2, that's section 4.2 of the Act, says that a court in deciding any matter which was to be decided, whether originally or on appeal, shall ensure a balance between the personal rights and interests of individuals. Note, the personal rights and interests of individuals. It's a balancing exercise, as against the rights and interests of the community as a whole. So, in performing this exercise, which is not the easiest exercise in the world to deal with, especially when you are dealing with the standards of reasonableness. What is reasonable? The court has to take into consideration the personal rights and interests of individuals and balance those against the rights of the community as a whole. And in doing so, the court shall take into account all relevant factors. What are some of those relevant factors? 1, the desirability for cultural and social developments. 2, the desirability of the pursuit of just economic rewards for labor. So somebody is having, promoting some cultural activity, bringing in some big name from abroad. Therefore, the court would take that into consideration, what promoters do. But of course, they have to balance it, depending on where that activity is taking place, against the wider interests of the community. The traditions of particular localities and of the society as a whole. Different communities differ in traditions, aspects of culture, and otherwise. So, for example, in some places, there's an active nightlife. And that is part of the tradition of the particular community. And that has to be taken into account. Versus a community that has little or no nightlife, and somebody comes in and attempts to do something that may disturb the peace and tranquility of a neighborhood that is traditionally quiet. So that's a factor that must be taken into consideration. Also, the sanctity of religious worship, teaching, practice, and observance. Some churches operate very late in the evening, very late at nights. The same principle would apply. The interest of the worshippers versus the interest of a community. So a church comes in to a traditional residential community, and the pastor is screaming at the top of his voice at 11 o'clock in the night, and that extends beyond the immediate worshippers in the building or otherwise, and can be heard for miles away. That has to be balanced, the right to worship versus the interests of the community. Then you have the rights of privacy of family life and the right of every individual to the peaceful enjoyment of his or her home and immediate surroundings. The rights of the disabled, the aged, the young, and the sick. And the necessity for orderly progress involving changing values and lifestyles, but preserving the fundamental principle of respect for the rights of others. And as the saying goes, your right ends where it begins to infringe on the rights of others. So that's private-public balance. Your private rights versus the rights of the community. And you have the traditional debate, where does one's rights or rights end, and where the rights of the community begin. And to put simply, as the Constitution itself has phrased it, your rights end where you then begin to infringe the rights and freedoms of others. So just to capture that bit we have looked at, the important thing is not just noise. Noise pervades everywhere. You have noise. The issue is excessive noise. And what is excessive is not fixed, but it depends on several variables, including the location. And what is excessive for some may not be so excessive for others. So the court employs what is called ordinary standards, ordinary sensitivities, not extra peculiar sensitivities of individuals in determining whether noise is excessive and unreasonable. So let us look, I want to look particularly at Section 22, because that's one of the main sections in the Noise Control Act that police officers in particular, those who are responsible for enforcing the act, need to be very familiar with Section 22. But just before we get there, let's look at loudspeakers briefly. Loudspeakers operated in dance halls or elsewhere. And Section 21 says, subject to the other provisions of this act. And when I say 21, I mean Section 20, subsection 1. Subject to the other provisions of this act, where a loudspeaker or musical instrument is regularly operated or used for the purpose of providing music for dancing or for other forms of entertainment at any location, whether private or public, located within 200 yards of any dwelling house, guest house, or hotel. So note, you're talking about a private activity or a public activity, an activity held in a private home or an activity held in some public hall, nightclub, or otherwise, and where it's located 200 yards of any dwelling house, guest house, or hotel. The level of noise shall at all times be reasonable, and the operation of the loudspeaker or musical instrument shall be turned down to a level determined by the Commissioner of Police by 2 a.m., except during the carnival period. So, it's okay if you have some activity out in some area that is not within 200 yards of dwelling houses. So you're out in some area that you have a party that particular night, over and away from the statutory minimum distance set out in the Noise Control Act, then you can go on for much later. But once you're within the confines of a residential community, then you are to operate it at a particular level that is determined by the Commissioner of Police. And that's one of the issues with the Act, the measuring of noise, as I always say, because the big question under the Noise Control Act is, of course, how much noise is too much? How much noise is too much? And there are noise meters available that measure the extent of noise, but most people don't have noise meters, not even the police. And I don't know for now, but to effectively police the act and operate in a scientific way, where you can actually say to a court, an independent court, not that the man was making a lot of noise, and the man says, well, no, I was not making much noise. My speaker was turned down. So nobody is talking in decibels. Unlike speedometers, if you have the speed guns, you can say somebody was driving in a 60 mile per hour zone at 120 miles an hour, because that is scientifically measured. So the man was speeding. Was he driving at 45 miles an hour, 60 miles an hour, 75 miles an hour, or possibly recklessly at 120 miles per hour? Because what matters is evidence, the presentation of evidence. And if the commissioner says, for example, at 2 a.m., you must turn down your music to X, then the question, of course, will be, how do you measure X? How do you know that this homeowner or public entertainer complied with the directive of the Commissioner of Police in that regard? But as we can see, that Section 20 that makes it an offense to play noise or play music above a certain level. It must be reasonable at all times, but when you are approaching the wee hours of the morning, that music must be turned down and the level determined actually determined by the Commissioner of Police. Section 21, which seems to be a major issue, excessive noise from vehicles. There is a style by many drivers now to actually operate what can be described as moving or mobile discourse. So somebody is driving his private vehicle, is driving through the town or driving through a residential area and has the music at full blast, all glasses turned down, and the entire community hears the blast. Now, that is addressed in Section 21 of the Act, which says, any person who, without written permission from the Commissioner of Police, drives or permit to be driven a motor vehicle on a road when that vehicle makes excessive noise from its engine, radio, tape deck, air horn, or any other parts or equipment attached, whether such equipment is built into the vehicle or not, and whether for the reproduction of music, speech, other sound, or otherwise commits an offense. So once you have a vehicle on the road and you do not have the permission of the Commissioner of Police to use it as a party vehicle for the purpose of making noise or playing loud music, you commit an offense. And note again what the section refers to: excessive noise from its engine. It doesn't even have to be confined to the radio or tape deck or whatever musical equipment that the driver has there that comes with the vehicle. Once it is excessive, then you are liable. And what is excessive at 8:30 in the morning, or what is normal, I should say, at 8:30 in the morning, might be extremely excessive at 11 in the night. So you have to take all factors into consideration. So 20 deals with loudspeakers operated in dance halls, party areas. 21 speaks to excessive noise from vehicles. And 22, that's the section I referred to earlier, a very important section which addresses the issue of unreasonable noise and the steps that can be taken in those circumstances. So 22, section 22 addresses control of noise. And 22 subsection 1 says that where any person is unreasonably disturbed, again, note this concept, reasonableness, is constantly coming up under the Act. Whether saying reasonable, unreasonable, unreasonably, or otherwise, it deals with the issue of reasonableness. So where any person is unreasonably disturbed, not just disturbed, but unreasonably disturbed by noise emitted from a loudspeaker or musical instrument, such person may lodge an oral or written complaint about the matter to the police, who immediately upon receiving such complaint shall investigate the complaint, and if satisfied of the reasonableness of the complaint, orally, followed as soon as is reasonably practical by a notice in writing, so you can make your complaint orally. You are just required to follow it up with a written complaint as soon as possible thereafter. Then they must notify the person who is suspected of being responsible for the noise. That's the police must notify the person who is suspected of being responsible for the noise that the complaint has been made, and shall request that person to reduce, maintain, or reduce and maintain the level of noise emitted from the loudspeaker, musical instrument, or event to and at a reasonable level, having regard to the circumstances. So, let's try to strip that apart. First of all, any citizen who is unreasonably disturbed by noise may lodge a complaint. To whom is the complaint lodged? To the police. Are police officers obliged to respond to the complaint? Yes. They have a duty to investigate, at least, because the complaint may or may not be baseless. So the duty of the police is, upon receiving the complaint, to investigate the complaint. Now, after investigating the complaint, they may find the complaint is of no moment. It is one of these ultra-sensitive persons who hears noise that is not unreasonable and decides to lodge a complaint. Or the police themselves, upon investigation, may find that the noise is excessive by all standards based on the community and the area from which the noise comes. And then, what do they do? One, if they are satisfied over the reasonableness of the complaint, then the police must notify the person who is being suspected of making the noise and say to that person, one, we have received a complaint of excessive noise, and based on what we are hearing, we want you to reduce and maintain that level of noise to X. And they are doing this based on all the circumstances of the matter. So that's the first thing. So you can make a report orally in writing to the police. Upon receiving that report, the police must act, and the police in acting as part of the requirement, the police are authorized to direct that the noise be reduced, and that the level of that reduced noise must be maintained. It is not reducing it when the police approaches it, or approaches the building where the loud music, excessively loud music is coming from, but to turn it off or to reduce it and continue to play at that reduced level. Now, what happens if the person who is requested to comply with an order of the court fails to do so, and that's an order of the court to reduce the noise? And Section 22(2) of the Noise Control Act may be helpful in that regard. And it says, if the person responsible for the noise fails to comply with a request from the police under Section 1, subsection 1, and that request, of course, is to reduce the noise to a reasonable level. Or where such person has complied for the time being with the request under subsection 1, but at any time thereafter resumes or causes or permits or suffers to be resumed the operation of the loudspeaker, musical instrument, or event in a manner which, again, unreasonably disturbs any person in the neighborhood, whether such person is the original complainant or not, and another complaint is made to the police, the police shall immediately visit the scene and shall undertake such investigations and inquiries as may be appropriate. Upon being satisfied that there had been willful non-compliance with the request by the police made under subsection 1, the police shall inform the person responsible that a complaint will be made against him or her for an offense under the relevant section of the Act, and shall institute the said complaint. Right? So here we have somebody complains. The police, in response, make a request for that person to reduce the noise. The person may or may not have complied with request number 1 to reduce it. And if the police have cause now to go back to the scene because that person has resumed playing the loudspeaker or playing the music in an unreasonably high manner, then the police, as the Act said, shall visit the scene, undertake investigations and inquiries as may appear appropriate, and being satisfied that there had been willful non-compliance with the request by the police under subsection 1, the police shall inform the person responsible that the complaint will be made against him or her for an offense under the relevant section of this Act, and shall institute the said complaint. So then it becomes the duty of the police to, as the saying goes, press charges or take whatever other steps that might lead to the seizing of the equipment or the seizing of whatever equipment that they can lay their hands on. And section 22(2) has what you call a proviso, where it says, provided that, even in the absence of a formal complaint, a police officer shall have the duty to act on his or her own initiative pursuant to the foregoing whenever he or she becomes aware of excessive or unreasonable noise, which is likely to disturb or has actually disturbed any person. So here it is. What the section is essentially saying, somebody feels disturbed by excessive noise, may then complain to the police. The police gives an opportunity to the person who is playing the instrument to turn down the music. Notwithstanding that directive to turn down the music, the person still persists. So, you better know that when you are persisting, that you turn out to be right. Because what can happen ultimately is that you can get charged, and all the other things that flow with getting charged, including not being issued a license wherever that is applicable under the Act. Section 2.3, that's 22.2.3, says that where the police have informed the person responsible that a complaint will be made against him or her for an offense as provided for under Section 2. A police officer not below the rank of sergeant may, with a warrant issued for such purpose, enter any premises and confiscate the loudspeaker and the musical instrument, or any of them, which the said police officer reasonably suspects to have been operated to produce the songs which give rise to the complaint, regardless of the ownership of such loudspeaker or musical instrument. Wherever possible, a receipt of the items confiscated should be given to the owner or person responsible for the items. So essentially, what is being said here is that the police have certain powers under the Act. And of course, as is always welcome, they would use the very soft technique at the beginning. Can you turn down your volume a bit? You don't even have to say it's disturbing me. When it's loud, can you turn it back a bit? However, if they make that request and the owner of the equipment persists, then the police themselves can enter the premises. You must, of course, have a warrant, and you can confiscate the loudspeaker and musical instrument. And, of course, the loudspeaker and the musical instrument, assuming that, or those pieces of equipment, are the source of the excessive noise. 22.4 says, the loudspeaker or musical instrument removed under Section 3 shall be kept in the custody of the police until the hearing of the complaint, reasonable care being taken to keep the same safe and secure, and the police shall produce the same to the court as exhibits in the case. So once the police remove, so the police have the power to seize musical instruments, to seize loudspeakers, and they also have the power under the Act to keep those in their custody until the hearing is completed. They will, of course, have to produce it in court as exhibits in the case. Where no proceedings, and that's Act, copy of the Act, Part 5. Where no proceedings are commenced within 14 days from the date of the confiscation of any loudspeaker or musical instrument under the section, which is Section 22, that loudspeaker or musical instrument shall be forthwith returned to the person from whom it was confiscated. No. You must, if you've taken a BB equipment, you must be taking it for a purpose. And in this case, if a police officer is seizing the equipment, then that police officer most likely wants to either, one, ensure as best as possible that they take steps to bring this matter to court in a timely manner. So you can't just be holding the loudspeaker and the musical instrument in the police station after you have seized it. What the Act says is within 14 days of the date of the confiscation of the equipment, then you must bring an action in the High Court. If you don't commence the action within a 14-day period, then you must return the loudspeaker or musical instruments to the person from whom it was confiscated. 6, the magistrate hearing the complaint may, in addition to imposing any of the penalties provided for in this Act, make any of the orders set out in subsection 7 as he or she may think fit in respect of the loudspeaker or musical instrument that have been confiscated. So, this basically addresses who hears the complaint after the equipment is confiscated. Is it a judge? Is it the Court of Appeal? Is it the master? Is it the Privy Council? No. It's the magistrate. The magistrate is charged with the responsibility under the Act to hear complaints with respect to excessive noise. And they may impose penalties. They may impose penalties as provided under the Act. Now, there's also what you call a provisor to that section, which says, provided that if in the opinion of the magistrate, the equipment ought to be forfeited to the Crown, and the magistrate makes an order to that effect, any person entitled to possession of the equipment ordered to be forfeited, whether or not that person was a party to the proceedings before the magistrate, may, within 7 days of such order, lodge an appeal to a judge in chambers against such order. Now, so the public complaint is lodged by a member of the public. The police intervene. The police request that the noise be turned down. The police leave. The operator ups the noise again. The police returns, and the police lay charges. If the police confiscate equipment in those circumstances, then they must list the equipment. They must take an inventory of the equipment and must seek to bring that matter to the court as soon as possible. The police can't just seize it and keep the equipment among themselves, because natural justice demands that the other side be heard. And remember, this is something new to the court. If you don't file within 14 days, you hand back the equipment to the owner. If the magistrate, however, hears the complaint and thinks that the complaint is established, then you move under Section 7 to see what the magistrates can do. A, the magistrate can order that the equipment or any of them be returned forthwith by the police to specified premises or to specified persons. So that's one kind of order. Return the equipment forthwith. 2, that the equipment or any of them be detained in the custody of the police for a specified period. You may ask for a detention of the equipment in the custody of the police for whatever reason. And so it makes clear that the equipment or any of them may be detained in the custody of the police for a specified period subsequent to the date of the order, not exceeding 3 months in respect of each offense. And that at the end of the specified period, the equipment thus detained be returned immediately thereafter by the police or to specified persons, to specified premises, be returned by the police to specified premises or to specified persons. Or the magistrate can order that the equipment, all the equipment of any of them can be forfeited to the Crown. And that, of course, will depend on the circumstances of the case, what the judge or magistrate in this case assesses to be in the best public interest based on the evidence. So that power extends to seizing the equipment and forfeiting the equipment to the Crown. That obviously would be one of the last resorts under the Act. And no liability shall arise on the part of the police for any action taken or in respect of any loudspeaker or musical instrument removed under Section 20 or ordered to be detained under subsection 6. So you can sue the police in their personal capacity for taking the action to remove the loudspeaker or musical instrument. You say, hey, it's you that come and do it, I will sue you personally. The law protects the officers. If you have to sue, then you have to sue the state. Good. So that is now Section 22 of this Act. Is one of the critical sections, as I always say. And what it does, in a way, not completely, but it addresses procedurally, not just the substantive law, and what the police should do or should not do, but it speaks to the time of complaint to the decision of the magistrate. So it's not the High Court, it says it must go to the magistrate. So, just to recap, what essentially Section 22 does, it says, 1, make a complaint. You make a complaint to the police, it says to the police, respond to the complaint. And it even was investigate immediately. But that, of course, would be subject to the resources of the police. But address the complaint. They may be able to make a phone call. Might not be that necessary to go there physically. But address the complaint. And in addressing the complaint, they would say, lower your noise. Lower your music, it's too loud. The person may or may not comply. If the person does not comply, then the police can do a number of things, including confiscating the equipment. What do they do with the equipment after it's confiscated? Do they say, well, listen, it's always yours? You can't make no noise again? We keeping that in the station? No. Remember, in the separation of powers, there are particular roles for everybody. And the role of the court is to adjudicate on the many matters that come before them. So the court that is responsible for adjudicating is the magistrate's court. So essentially, the police cannot keep the equipment they seized, even though they have the power to seize the equipment. Within 14 days, they must go to the court with their formal complaint. What happens after they make their complaint to the court, and the court hears and determines the matter? The court, and the court here means the magistrate's court, can then either order that the equipment be returned forthwith by the police, and it be returned to either specified premises or specified persons. Or you may say, detain that equipment further. We ain't finished with this matter yet. Detain the equipment. But the court itself is limited by the law to detain that equipment up to a period of 3 months in respect of each offense. And when that 3-month period, or whatever period that the court imposes, when that period expires, then the equipment must be returned to the owner. And it also says that the equipment, or any of them, may be forfeited to the Crown. What happens to police officers who enter premises and seizes equipment? Remember the right to personal property? Those persons are protected under the law. Those persons who go in and seize the equipment, and the law says no personal liability shall arise on the parts of the police for any action taken, or in respect of any loudspeaker or musical instrument removed under subsection 3 that we mentioned earlier, or ordered to be detained under section 6. So it is also very important to know that whether this act was in place or not, there is the common law which we rely on over the years before we pass our own laws. You can bring an action against a neighbor or somebody who is constantly interfering with the peaceful and quiet occupation of your flat. And you can do so by going to the High Court for an injunction and also damages for nuisance. But the Noise Control Act has been greatly enhanced by the passage of this legislation, albeit a long time ago, but it's still as relevant today as otherwise. As I always say, the issue is not so much the lack of provisions in the law for noise. We have lots of provisions in the Act, but it's the actual action being taken. And I dare say regulations to better guide police officers and otherwise to use this act to ensure that members of the public peacefully and quietly enjoy themselves, and that others, even those who get permission via a license to hold events, do not abuse the permission given, because they are sticking to what the Act contemplates, the making of reasonable noise, even when you have been afforded a loudspeaker. So What happens, and in the short time I have left, I should probably just look at the interests of third parties, because the equipment seized might belong to somebody else and not the man who is playing it at an excessively loud level. And the law provides, that section 23, that where any equipment has been forfeited under section 22, because remember, that is one of the powers of the magistrate under subsection 22(7), that you forfeit the equipment. In other words, the crown gets it, the state gets the equipment. A magistrate may, on application by a claimant of the equipment other than the person in whose case the forfeiture order was made, make an order for the delivery of the equipment to the applicant if it appears to the court that he or she is the owner of the equipment. So, the man who was playing the loud music can't apply after and say, well, give me back the equipment. He or she may appeal to a higher court against the decision of the magistrate. But an innocent third party who may have rented that equipment to the person who may not have been on the scene at all, but who actually owns that equipment, may apply to the magistrate for a return of that equipment. And section 23(2) sets time limits. It says that no application may be made under subsection 1 by any claimant of the equipment after the expiry of the period of 28 days, beginning with the date of the forfeiture order, which was made in respect of the equipment. So again, if you are an innocent third party and you own the equipment, then you must apply within a 28-day period. And that period begins to run from the date that the forfeiture order was made. What do you have to satisfy the court when you make that application as an innocent party that this equipment belongs to me? You must satisfy the court, 1, that he or she had not consented to the offender having possession of the equipment. Right? 1, he or she had not consented to the offender having possession of the equipment, or 2, that he or she did not know and had no reason to suspect that the equipment was likely to be used in the commission of an offense under the Act. And it goes on to say whether the Commissioner of Police is of the opinion that the person in whose case the forfeiture order was made is not the owner of the equipment, he or she shall take reasonable steps to bring to the attention of the person who may be entitled to do so his or her right to make an application under subsection 1. So you can't wait until the time run out and tell the man that there was a forfeiture order with respect to your equipment. And just quickly, an order under subsection 1 does not affect the right of any person to take within the period of 28 days beginning with the date of the order proceedings for the recovery of the equipment from the person in possession of it in pursuance of the order. And if no application is made under this section within 28 days of the forfeiture order, the Commissioner of Police may dispose of the equipment. So, as we can see, there are adequate measures within the law to deal with noise. For some strange reason, not many of these matters come to the court. I don't know why. You have complaints every day, but people can also bring private complaints if the police do not act. So I hope this session was useful. Thank you. Until next week.